Good evening and welcome to Ask the Attorney. I'm your host, Amy Rao Mohan, and this is a show where you get the opportunity to ask an attorney any question you would like, whether it's a civil or criminal question, and you get the expertise of an attorney who practices here in the Middle Tennessee area. And today we're fortunate to have Clint Kelly with us from the Kelly Law Firm in Hendersonville. Thanks for coming on today.
Thank you for having me.
And tell me a little bit about your practice, Clint. You focus mainly on medical malpractice cases.
That's right. I've been doing this for 15 years. I'm a certified medical malpractice specialist, and we do some also pharmaceutical liability, defective device and drug cases, but the mainstay is medical malpractice.
And tell me a little bit about that area for people who don't know. It's not just your simple case where you get to have a couple witnesses. I mean, it really requires a lot of research, experts, quite a long process.
They're probably the most difficult cases to litigate. At least that's been my experience. The best lawyers, certainly on the defense side that represent the doctors and hospitals, handle medical malpractice. And that's basically a broad term for patients who have been injured or have died as a result of a physician or a healthcare employee, what we call departing from the standard of care or failing to give basic care to a patient.
And if someone thinks they might have a medical malpractice action, what can they do?
Well, first thing they ought to do is contact an attorney. Contact an attorney who is preferably certified in medical malpractice, who does this for a living. And there's no harm in picking up the phone and calling and asking about, whether the facts of the case justify an investigation. I would say less than 1% of people who call actually have a meritorious case that can be pursued. They're very, very rare cases that are meritorious for a lot of different reasons.
Okay. And we're already getting a few calls in, but we ask that you please call that number on the bottom of your screen, 737+, 737-7587, and Clint is here to answer all of your questions. Let's take this call from Lisa here. Hi, Lisa. How can we help you today?
Well, I would like to know if it's legal for a sitting judge to represent a family like a lawyer. Can a judge be a lawyer still?
Okay. How does that affect the professional rules of ethics, I guess?
I would not want a judge to represent, a sitting judge to represent a family, certainly not in the area where the judge is practicing. I think that would probably be inappropriate. The rules nowadays, as I understand them, is that if you're a judge, you're a judge. You don't represent people, certainly not in the area where you live. So that would be concerning to me if that's going on.
Right. And there is a governing board for lawyers so that if someone thinks that, I guess there's some type of malpractice, legal malpractice going on, they can report that to the Board of Professional Responsibility.
Correct. If they think there's a breach of ethics, and there's also a governing board for judges, the Commission of the Judiciary, very fine board that looks out or polices their own, and that's something that can be reported to them as well.
Okay. Well, that's an interesting question. And again, please call 737+, 737-7587. And I know we were talking about this a little bit before the show, and especially because you deal with malpractice. Tell me your thoughts about this case in Texas that the news media has really been focusing on.
The Munoz case, it's a heartbreaker. It's a woman who was pregnant. I believe she was 37. My memory serves me. And she was in a hospital and was brain dead. And under Texas law, if you're brain dead, you're clinically dead. But because she was pregnant, the doctors couldn't, for lack of a better term, pull the plug because they were trying to see if she could deliver the child, I guess by cesarean section. The husband, Mr. Munoz, objected to them keeping her alive. His perspective was they were just basically using her as a conduit or a piece of meat to deliver the child if the child could be born. And so the husband sued the hospital, claiming cruel and inhuman treatment, and the husband prevailed in court, and the judge allowed the husband to regain custody of his wife so that she could pass away and be buried with dignity.
Could there be any type of medical malpractice action associated with that?
That is a very good question because there's a lot of ethical questions involved. The fetus is a person, at least my understanding is in Texas, and I think it is here in Tennessee, so the fetus has rights. If the hospital acted without authority to perhaps pull the plug on the mother, and the mother could in fact give birth to the fetus, then the fetus would have an action against the hospital for wrongful death. I've never heard of that happening, but it's always a first time for everything. But these type of situations, because medical technology has advanced so far, we're going to see more and more situations like this where you're going to have ethical dilemmas, particularly with women who are pregnant and children become viable at a younger point in their term.
And a lot of people often call this show and they say, you know, they went to the hospital 2 years ago and had this happen. Tell us a little bit about the statute of limitations and how that works with medical malpractice
That's
actions.
a great question. Most people don't think at the time that they've been wronged that the clock is ticking. In Tennessee, we have a 1-year statute of limitations, meaning that you must file suit within 1 year of the date of injury or within 1 year of the date that you discover your injury. Some people will sit on their rights, they don't even know it, and they won't contact a lawyer until after a year in which they've been injured or discovered the injury. And in that case, their claim would be barred. And I've had that happen many times. A lot of my colleagues have had that happen. And it's very painful to have to tell someone that you have a meritorious case, but we can't bring it because it's time barred.
And you also need to have, I guess, an expert as well to, in order to file that lawsuit?
Absolutely. I mean, the law in Tennessee is that if you're going to file a medical malpractice action, you must have an expert certify the case. We call it a certificate of good faith. The expert must state that the case has merit, meaning that there's been a deviation or departure from the standard of care applicable to the professional, and that departure caused an injury to the patient or caused the patient's death. If you don't have that, the case can be dismissed. So plaintiff lawyers who handle or represent patients must have an expert on board.
Okay. And again, please feel free to call anytime, 737 plus 737 7587. I'm losing that number there, but this is a chance to ask Clint Kelly, who practices in Hendersonville, any question that you may have. It doesn't necessarily have to be a medical malpractice question, but it is an area that you specialize in.
Yes, it is.
And is this something that you've always specialized in since you've practiced, or
I started handling these. Yeah, I started handling these cases about 3 years after I started practicing. My father and I got into it. We represented a family member of a paralegal who was paralyzed. She had a very significant aneurysm that was misdiagnosed as a migraine. And this went on for a period of about 4 days before it was ultimately diagnosed. And unfortunately, by that time, that aneurysm started bleeding down her spine. And that's what ultimately caused her to become paralyzed. And we took that case and got some help from some other lawyers who have been doing this work for some time, because you really, when you're starting out, you need some assistance or advice. And we ended up trying that case in Gallatin and got a good verdict for the family. Okay. And they deserved it.
And tell me how tort reform has sort of affected your clients as well as your practice.
It's changed everything. It has put, in essence, a limitation on cases that you can take, because there's what's called a cap, or $750,000 cap on non-economic damages, meaning that if a patient is injured, significantly injured, let's say the patient loses an arm, that patient can sue and get damages for lost wages. But if the patient is, say, 70 years old and retired, then that patient doesn't have an arm, and the most that patient can recover is $750,000. There are a variety of different cases that would be meritorious, but we can't take it because the physicians or physicians insurance company or the hospitals will defend the case to the limit, because they know their exposure is only $750,000. And there's a number of different changes in the tort law that are making it more difficult for us to bring these claims.
Okay, well, some interesting points there. And again, please call that number on your screen. We're going to take a quick break, but we'll be back with Clint Kelly after this.